Is Mead Byers here? Where are you at? No. So in the matter of the people of the state of Michigan versus Kenneth James Armstrong, file number 23-21474FH, 23-21475FH, 23-21476FH, 23-21478FH, 23-21549FC, 23-21550FH, 23-50607PP. Those matters have been adjourned to June 28th at 8:15 in the morning. Is Jesse Smith in the courtroom? Jesse Smith? No. Jesse Smith, courtroom 2. Good morning, Mr. Goldstein. I do not have Jesse Smith either in the waiting room or in the hallway. So I didn't know if you wanted to give your client a call. He's usually here.
I will do that, Your Honor. Thank you.
Thank you. Mr. Murphy, are you ready on Mr. Fanslaw?
Yes, Your Honor.
And this is in the matter of the people of the state of Michigan versus Brian James Fauso. I'm sorry, I mispronounced it. File number 24-21760FH. I have Matthew Murphy appearing on behalf of Mr. Fauso, and I have random prosecutors all over today, but I don't think any of them are here for this file. So, Mr. Fauso, let me. Let's see. So, Miss Adams, did we? Okay, this is not a sentencing, that's why. All right, so this is the time set for contempt sentencing and a pretrial conference. I have a letter dated May 22nd of 2024 from Darren Coast, who is my pretrial services coordinator. He states on April 24th, Mr. Fauso pled guilty on a contempt for registering numbers on his machine. It was ordered to get set up for the driver's intervention program and to attend AA on a daily basis. He indicated he is registered for the June 8th class. Today is the actual contempt of court sentencing. Mr. Fauso registered numbers yet again on May 12th, blowing a .054 at 11 p.m. and a .053 at 11:15. And we do have a warrant for his arrest for this latest violation that was issued. And Mr. Murphy, the last time we were here, let's see, I had it was in the room. All right, so Mr. Murphy, are you ready to proceed for sentencing today?
Your Honor, we're ready to proceed for sentencing on the contempt that he pled guilty to. Obviously, if the court wants to adjourn that because of the fact that there's another thing. In regards to that matter, Your Honor, I mean, with the underlying charge still pending, we'd ask the court to consider placing him on probation on that contempt of court to allow the court to basically have a stronger leash on Mr. Fauso while the underlying case is going. Of course, obviously with the bond conditions in place, and obviously I wasn't aware of the new violation, the new allegation, but I do believe that first, like Incarceration pending the underlying charge being worked out isn't necessary right now. Mr. Franville obviously is here. He's not trying to flee. What we're seeing here, I think, is the tip of the iceberg in regards to his issue in regards to alcohol. That's why I was asking the court to consider not incarceration and probation in regards to that. So whatever happens with the underlying charges, you still have him on probation for that, for the contempt. Try to work with that, Your Honor. So I would ask the court to consider that.
All right, I don't have really the resources to put him on probation on a contempt of court at this point. Mr. Fenslow is charged with operating while intoxicated, third offense felony. So, Mr. Fenslow, are you employed?
Yes,
Where you work?
for job automotive.
Okay. Mr. Coast, I did review the statement that you provided us yesterday. Has we registered any numbers since May 12th?
No, Judge, not since May 12th.
And how many times a day is he doing PBTs?
He's doing PBTs twice a day. Once in the morning and once in the evening.
Can we do alcohol tethers?
We do, Judge. We have alcohol scram units, which attach to the ankle, which is 20 continuous monitoring 24/7.
Okay, and you verified he works at Kirchhoff? Mr.
I don't
Coast,
have
or where-
verification of that, Judge. I mean, I could get verification of that, however.
All right, do the people want to weigh in on this at all? No, okay, all right, so Mr. Murphy, what I will do is I'll switch him to a scram unit.
Your Honor.
He's got to put that on today. Sir, one incident, again, of consumption of alcohol, then I need you to understand you're gonna sit in jail till this trial is done. Do you understand? You have a serious problem. I think you're making an effort not to consume alcohol, but you obviously are an alcoholic. So I'm also, have you been doing AA daily?
Yes.
You got your sheets? Okay, so I'm gonna amend his bond to add that he has to do a scram unit. Mr. Coast, I'll have him meet with you in the hallway.
Yes, ma'am.
Is that, okay? And then I need you to provide your verification of AA to Mr. Coast every 2 weeks. And that's 7 days a week, right?
Yes.
So do we need to, what's the plea offer in this file?
Your Honor, right now it's as charged. I was just gonna ask for a brief adjournment of the underlying charge, the pretrial, to try to speak with the prosecutor about any possible change on that. Obviously, I think we want to resolve this fairly quickly here to get Mr. Cranflow moving along with his life.
Right. So how long, how far out do you need a pretrial?
Maybe 2-3 weeks, or if it's for schedule best, I know, but yeah.
That's not gonna work. Miss Adams, July 3rd or July 10th still available?
I can't do July 3rd, Your Honor. I'll be.
July 10th still available?
It's we were just doing arraignments, but
Okay, July 17th.
July
I
17th
don't know
is
what-
good.
Okay, so we'll set this. Can I get a notice from Mr. Fenslow? So we'll set this for another pretrial on July 17th at 8:30 in the morning. Mr. Murphy, if you get a plea offer that your client wishes to avail himself of, you can bring him in earlier for a plea.
Yes, Your Honor. Thank you.
And he probably sobriety court might be a good thing to have him screened for.
Yes, Your Honor. Thank you.
Okay, Mr. Fenslow, have a seat at that first row somewhere and we will get you a notice of hearing, okay? And then when you're done, I need you to go to the hallway and meet with Mr. Coast. Thank you.
Your Honor.
Mr. Murphy, you have another one.
Your Honor. Like for 10 seconds.
Sure.
Potential with the case number of Armstrong. You adjourn all this.
You're all marked.
Okay.
Fine.
It wasn't on right before I left.
I show all of them, but I don't know if we did that just because of Sam or David.
Not me, I would post it.
David.
Yeah.
Do you want to set it? Oh, I mean, it's separate, usually one sooner than one. Can I ask Mr. Goldstein? Okay, you sure?
Yep.
Do you want me to ask Mr. Goldstein if you would like the date sooner?
See my calendar, just make sure the 24th.
Okay,
20 is fine.
if it is at the 28th, it'll be like July.
20 is fine.
Okay.
Your Honor, I spoke to my client. He thought it was tomorrow. He'll be there around 10 o'clock, so I'll come back around 10. I assume you're going to be doing stuff all morning, so.
Yeah, I'm here all day, so yeah, that'll work, fine. Anything for you, Mr. Goldstein?
Thanks, Your Honor. I'll see you at 10.
All right, thanks. Okay. All right, thank you. So, Mr., where'd he go? Sam, are you ready on Milo Leatherwood?
I am, Judge.
Is he here?
He is, I'm not.
Mr. Leatherwood, you want to step up to the podium? Just come right up here. All right, this is in the matter of the people of the state of Michigan versus Milo Kenneth Leatherwood III, file number 24-21751FH. And Salvatore Malaro appearing on behalf of Mr. Leatherwood. Mr. Leatherwood is in person from the Michigan Department of Corrections. I also have Phoebe McClure here on behalf of the people. So this is the date and time set for sentencing. Was he able to be present this morning?
Yeah.
Excellent, thank you. Did you go over to the APD office? All right, so thank you for your patience this morning, gentlemen. All right, so
Judge, this is not Milo Leatherwood.
you're not Milo Leatherwood?
No, you're right.
Well, I'm not gonna send you that. So I think, what's your name?
Jones, you're on.
He's Judge Olsavers. Wrong guy. It was nice to see you. Have a good day.
So. Keep with his ear down.
You got his paper.
Mr. Leatherwood, yeah, you probably need that paperwork back. I didn't think he looked familiar, but I see a lot of people every day, so. Hi, Mr. Leatherwood. I'm good. So this is in the matter of Milo Kenneth Leatherwood III, file number 24-21751FH. I have Salvatore Malaro appearing on behalf of Mr. Leatherwood, and I have Phoebe McClure appearing on behalf of the people. So this is the date and time set for sentencing in this matter. Mr. Moore is on Zoom. Mr. Malaro, just so you know, he is here. So Mr. Leatherwood, did you get a chance to review your pre-sentence report with Mr. Malaro?
Yes, ma'am.
Are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, Your Honor.
Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Does the pre-sentence report should disclose any prior convictions in which there exists any known constitutional defect?
That's my knowledge.
Probation department, or do you wish to challenge anything, Ms. McClure?
No.
Okay, the probation department has computed the minimum sentencing guidelines to be 14 to 29 months. Do you agree with that computation of guidelines?
I do agree with it.
All right, before the court passes sentence, is there anything you would like to say on behalf of your client?
Judge,
I know about the cops too. There is the agreement to
Right.
the low end of the guidelines.
Judge, I've met with Mr. Leatherwood now a couple times. He's always been pleasant and appropriate with me. I know there's been issues with him in other matters. We've had good conversations, and my only hope is that Mr. Leatherwood takes this additional time to reflect on his behavior with people that, he has no control over, and that the court sentence according to the recommendation.
All right, Mr. Leatherwood, is there anything you'd like to say on your own behalf?
To be honest mistake, I was having a bad day. It won't happen again.
I appreciate that. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law and protection of society. So do you have a potential out date?
Yes, 2032.
2032. So we're moving up on that date, right? So we don't want to get in trouble like this because you want to get out.
Yes, I do.
It's been a long time for you. So, sir, I hope this is a one and done and it's not going to happen again. I know it's probably hard to have a bad day in a place where you're controlled every movement you make, but these are the things that will keep you in prison.
I
Okay?
understand.
All right. The sentence of the court that you will serve 1 year, 2 months to 5 years with the Michigan Department of Corrections. I can't give you any credit for time served because you were a prisoner at the time the offense occurred. There is a $130 crime victim rights fee and $68 in state costs. So, Mr. Leatherwood, you do have the right to appeal this sentence, and my bailiff's going to hand down to your notice of right to appellate review. Just
Your Honor.
initial and yes, Mr.
We
Moore.
need to address if it's, that it's consecutive.
It is, yeah, it is consecutive. So,
Thank
Mr. Leatherwood, you're just gonna initial and date one copy for my records to acknowledge you received the paperwork.
All right.
The other 2 copies are for you, and if you wish to appeal this sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Or you can do it here if you wanted to, okay?
Yeah.
So my bailiff's gonna hand that to you. Right. So, Mr. Leatherwood, I wish you the best of luck, okay?
Thank you.
Thank you.
I love you, President.
All right, thank you, sir.
Judge, while you're shuffling between cases, I sent you a chat message.
She does this to me and I have ADHD and it's like really bad. Let me see, where's our chat? Okay, will you have that attorney come up here, please,
Yes, ma'am.
right
Thank you.
now? But he's not here.
Not here.
Okay. Okay, thank you. So, Mr. Murphy, they're currently bringing Mr. Tatum over.
Your Honor.
So. let's see. Okay. I don't hear that. All right, is Mead Byers here?
Yes, Your Honor.
All right. Mr. Byers. Feeling fancy today now.
And Judge, I do have someone who wishes to speak on this case.
Okay. I know. There we go. All right, this is in the matter of the people of the state of Michigan versus Mead Jonathan Byers, file number 23-21531FH. I have Matthew Murphy appearing on behalf of Mr. Byers, and I have Phoebe McClure appearing on behalf of the people. This is the date and time set for sentencing. I have received a pre-sentence report from district court, and I show that we mailed that to your office on May 15, Mr. Murphy, and you've had an opportunity to review that with your client.
Yes, Your Honor.
All right. So, Mr. Byers, you've had a chance to review your pre-sentence report, and
Please
there's a
speak up.
victim impact statement. You reviewed that as well?
Yeah.
Okay, it was about the request for restitution, and did he get to see this? Did you get to see this?
Yes.
Okay, all right. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yeah.
Okay,
Sir, please speak up.
you gotta speak up a little bit for me. Okay, because we record this, so. All right, does, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right, does Miss McClure, do you?
No.
Does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No,
Mr.
Your Honor.
Murphy. All right. There are no guidelines on this because it is a misdemeanor. I do have someone who wishes to speak today. So, Mr. Byers, can you sit in the far seat, please? And then Mr. Murphy, have a seat. And Miss McClure, you have the person that wishes to speak come up. Ma'am, you're gonna step up to the podium and you're gonna look directly, you're gonna speak to me, okay? Okay, so what is your full name?
My name is Becky Preisner.
Mr. Murphy, can you move that microphone for her, or she can move it, bend it down, there you go. State your first name again
Becky Preisner.
and spell your last name.
PRAJZNER.
All right, so you're soft-spoken, so I need you to speak loudly, and what would you like to say?
So what I would like to say is all I want is for Mead Byers to pay the entire cost of my radio to fix it. The cost is $1,422.60. Since there is no warranty on it because he punched it. And every time I get in my car, it is a constant reminder of that night and the last memory of our relationship. I just want to put this all behind me, and my hopes is that he will finally get help with his anger and his alcohol problems so that something like this does not happen again or to someone else.
Thank you, ma'am.
Thank you.
You can go have a seat. Okay. Before the court passes sentence, you guys can stand back up, please. Ms. McClure, is there anything you'd like to say on behalf of the people?
Yes, Judge, the only thing I'll ask is, this case is one that was set for trial, and in preparation for trial, I spoke to a number of individuals who are close with Mr. Byers, and the common theme that I kept hearing was he has an alcohol problem, or an anger problem, or they go hand in hand. So I would just ask the court take that into consideration in fashioning its sentence and its probation terms. Otherwise, obviously, we're also asking for that full restitution amount. I know in working out the case with Mr. Murphy, there was some back and forth. We weren't sure if there was an insurance deductible, that type of thing, but I was mistaken, and it is that full amount. I think that was disclosed before the plea. So I'm just asking for that. Thank you.
Mr. Murphy, anything you'd like to say on behalf of Mr. Byers?
Your Honor, as Ms. McClure indicated, there was back and forth about the restitution amount. Mr. Byers was under the impression that it would be a deductible amount. At this time, he was going to ask the court to consider a restitution hearing. I'm going to speak with him further about how we want to approach this, if we're going to be able to do an estimate ourselves, or what we're going to do in regards to that matter. But in regards to the restitution, that was what he was asking. For sentencing, Your Honor, obviously, Mr. Byers has been on bond conditions since the outgoing of this case. The bond conditions placed on a district court included no alcohol use. There have been no violation of those bond conditions. This incident obviously occurred after a festival. Mr. Byers admittedly was drinking, he wasn't driving. I don't believe that his consumption of alcohol that night was anything out of the ordinary in regards to other people that were there. Just obviously this incident occurred. Now, obviously this involved Mr. Byers and a significant other that he's had a relationship with or had a relationship with for a long period of time. He understands, and we understand that, the situation is over now. In regards to that, he has agreed to contact her. He does wish that, her the best and just they both go their separate ways. We do understand that this incident, obviously, Mr. Byers, our opinion of the matter is not that he was being assaultive. Obviously, he didn't plead to an assaultive crime. He does apologize though for any of his behavior that would cause any type of distress to Ms. Heisner. I'm sorry if I mispronounced that. He does apologize for that, Your Honor, but I don't believe that's necessary to have him on a long-term probation to monitor him. I don't believe it's necessary to monitor his alcohol consumption because again, he's been on bond conditions, there's been no violation of that, and he has not been consuming alcohol. He hasn't had any issues with that. So that's what again to consider. I'd ask for to consider fines and costs in this matter. I don't believe a period of probation is necessary. I don't believe judicial resources are necessary to monitor Mr. Byers. Obviously, if he has any issues with the law, he'll be charged accordingly. I believe, again, the only issue outstanding now will be the payment of restitution amount, which Mr. Byers is asking the court to consider setting a hearing for that, Your Honor. And obviously, if based on the restitution amount, how long you have to pay that, would be the only amount of time you'd be under the court's supervision is what we're asking for.
Ms. McClure?
The only thing I want to respond to is the restitution request. At the time of the plea, I know we put on record that the deductible was $1,000, but Mr. Byers knew it could be up to $1,400.
Actually, at the time of the plea, we set up to $1,700.
There we go. Yeah,
So-
I know it was placed on record.
No, up to, that's why.
You always have a right to request a restitution here. So that's not an issue. All right, Mr. Byers, anything you want to say on your own behalf?
No, ma'am.
So, Mr. Byers, you have a history that would indicate to me that you have an alcohol problem and or an anger management issue. You have a B&E from 2001, you have an impaired in 2001, marijuana, which was set aside. Those are a long time ago. You
You said a
violated,
B&E, ma'am?
I'm sorry,
You said a B&E? I've never had a B&E.
misdemeanor one back in 01.
I've never had a breaking and entering. I don't know what that is.
Well, I don't have your lien, but it shows on your prior record. So anyway, I showed that you violated pretty much all your probations except for 1 or 2. You have an impaired from 2001. You have, hey, I'm talking. Thank you. You have an MIP from 2003 that was set aside. You have an MIP contempt, you have an aggravated assault in 08, you have an OWI in 09, and you have a disorderly in 2015. So they're spread out, but it's enough to indicate to me that you probably have issues when you consume alcohol and you do stupid stuff. That's what that's, I'm talking, not you. So that's what I see when I look at this. So, I saw you kind of make a face earlier and I understand, but on paper, you have a problem and you need to address that. And sometimes we don't recognize when we have a problem until something bad happens. So I am concerned, but I think that it's spread out enough that you probably can deal with this. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the class of confinement, the sentencing guidelines, the report and recommendation of the probation department. Here, I'll just stop while you guys do that. What do you need? Do you need a moment?
I'm sorry, Your Honor, I was going through his criminal history. There's an issue with it. I didn't realize beforehand. I just wanted to make sure if he wanted me to address.
Do you
it.
have access to his criminal history, Ms. McClure?
Yes.
Because the issue I obviously run into, again, I apologize for not addressing it beforehand, looking at it again now, obviously with an MIP in 03, the suggestion and the B&E and the prior behavior before that may have been his father that was attributed to.
Okay, well, hold on, Ms. McClure can look.
And what was the date of the one?
We have 01.
The only thing I have is in 2008, a home invasion 2nd degree that was reduced to an attempted.
I don't even have that one. I have an egg assault in 2008. What's your dad's
I
name?
have an Agnesol, who does an Agnesol.
Ricky Byers, I've never had a B&E, ma'am, that's why.
Well, there are misdemeanor ones, so
The 2008, that was the home invasion, attempted home invasion.
home invasion. I don't show on my criminal history that, but
I also show the Agnesol,
2008.
and then a number of OWIs, and then
Yeah,
I show a disorderly in 15, an OWI in 09,
yes,
ag assault in 08,
that is all correct. It's just
an MIP in 03.
the B&E, I've never had a breaking and entering, never.
I have an impaired in 01, is that you?
yes.
Yes.
Okay,
I apologize, Your Honor, I just wanted to make sure everything was correct.
right, and then the B&E from 01, do you show that?
No, all I'm showing is the 2008 home invasions. I don't show any other B&E.
Okay,
That would be correct, ma'am.
I think that was probably your dad maybe or something.
I have no idea, but
So you don't
it's
show,
definitely not me. I've never had a B&E.
how old were you in 2001?
Yeah.
Okay, so I'm gonna write on
19,
here,
20, I would have been like 18.
not be him, and you don't show it either?
No.
Okay, so I'm gonna cross that off. All right, so. Anything else?
Nothing further, Your Honor.
All right, the criteria and reasons for the sentence and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication of law, and protection of society. So, Mr. Byers, restitution may or may not be high. You have a right to request that hearing. So I'm gonna order the 12 months probation. To be honest, if you comply with everything, they usually will petition to release you early if you've completed all programming and done what you needed to do. So 12 months probation, I'm gonna order restitution in an amount of $1,422.60. You can request a restitution hearing if you would like. You're not to use any illegal controlled substances or alcohol. There'll be random testing, search and seizure. So if they feel you violated the terms of your probation, they can enter your car, your house, your phone. You're not to have any alcohol in your home or illegal controlled substances. I am going to order anger management class, no contact with Ms. Prajner. All right, and that is it. Anything else, Ms. McClure?
No, thank you.
All right, so, Mr. Byers, I would ask that you report to district court probation. Ms. Adams, is it next Thursday? They'd like me to send them down? Oh, she's not there. How about next Thursday between 8 and 10? Can you do that?
That's correct, Judge.
All right, so next Thursday between 8 and 10, I need you to report to Mike McCarron down in district court.
Yes, ma'am.
And he'll be your probation officer, and if Mr. Murphy and you decide you want a restitution hearing, Mr. Murphy will schedule that through my assistant. All right?
Yes, Your Honor. Thank you.
All right. Oh, I gotta do fines and costs. I'm sorry. You probably want to get paid. So there is $750 in court costs, $450 court-appointed attorney fee, $75 crime victim rights fee, $50 in state costs. There is $100 law enforcement fee, right? We got that too.
Yes.
And then, because it's a misdemeanor, is destruction of property. He pled to less than 200, right?
Correct.
So there is 125. Oh, I misspoke. So there's $125 fine. This is a misdemeanor, so there's 50. I'm gonna lower that. $50. No, that was right. $75 crime victim rights fee and $50 state minimum cost. So that'll be paid off during the 12 months. If you pay it off early, complete all your programming, usually after 6 months, they'll release you from probation, all right? So you do have the right to appeal this sentence, so my bailiff's gonna hand down to you. Ms. Adams, could I get paperwork from Mr. Byers, please?
Oh, sure.
Unless it's
appellate
with-
forms?
I don't see it.
No, it wasn't. in-
I'm looking at my stuff, Jeff. It's not in my stuff either. Alright. So in a minute, my sis, Oh, he has it, Miss Adams. So my brother's gonna hand down to you your notice of right to appellate review paperwork. One copy is for our records, just to acknowledge you received the paperwork, so just initial and date it. The other 2 copies are for you if you wish to appeal your sentence. You would fill out the information on the form and mail it to the address listed on the form within 42 days. If you could call and have him bring Mr. Tatum down.
Thank you, Your Honor.
All right, Mr. Murphy, Mr. Tatum is still not here yet. So do you have any info on Judge Olstave you want to go take care
Yes, Your Honor, I do.
of? Okay, why don't you go do that? The record should reflect, I received that signed copy of the notice of right to appellate review. Mr. Malaro, you're doing that thing again, and I don't know why you're here. Oh, on the juvenile case? No.
No,
What are you here for?
I was here for Mr. Leatherwood. Do I have to leave immediately?
But we're done? No, because I keep looking for a client for you to sentence and I can't find anybody. So you're done, you're just hanging out.
Fans from your courtroom or something?
No, you're just hanging out. Okay. So,
Just hanging out.
okay, so
Mr.
are we ready, Miss Hennigan?
I'm ready.
All right, so I'm gonna go off live stream.